What's up, everybody? Welcome back to the Court of Random Opinion. I'm Lauren Neidigh. We have yet another docket update in the Blake Lively versus Justin Baldoni saga today. Now, this morning I went over Wayfarer had entered a document stating that the parties did not come to an agreement on the subpoena issue. Blake Lively, apparently her parties gave a little, but they were still asking for like overly invasive subpoenas. So the judge is going to end up having to rule on this. Now, Blake Lively's parties have responded, and so we're going to go over that document really quickly. This is going to be a short update, guys. Oh, I want to make sure you can see that. All right. Dear Judge, we write to address the Wayfarer party's letter to the court in connection with the court's February 19th order taking under advisement the Wayfarer party's letter motion for discovery. That letter motion concerns purported objections to third-party subpoenas served by Ms. Lively. Now, these were to multiple cell phone carriers. They were asking initially, apparently, for like location data information and all kinds of weird shit that you just wouldn't really want to volunteer to somebody who is, obviously out to make you look pretty bad. So why would anyone not? And I know they initially had said like, well, they don't want that information out there because it's going to prove our point and make them look bad. But I disagree. Even taking out of the context of this case, if somebody were asking for that information, I would think that the person on the other end of those subpoenas, I would be like, well, I absolutely do not want you to have that information. I don't think it's any sort of indication of guilt or anything of that nature. Anyways, moving on. On February 20th, the parties held a meet and confer, during which counsel were able to agree that removing any request for locational data from the subpoenas and providing express language to clarify, as had previously been communicated to the Wayfarer parties, that the request applied exclusively to non-content information would allay certain of the Wayfarer parties' concerns. Nonetheless, counsel for Wayfarer parties continued to maintain that the subpoenas were overbroad. Counsel for Ms. Lively expressly requested that the Wayfarer parties identify any modifications that would allay their concerns with the subpoena's putative overbreadth. God, putative overbreadth. That's not a phrase I thought I would ever say. But the only limitation that the Wayfarer parties were able to identify was their demand that Ms. Lively limit her request to contacts with specific third-party telephone numbers identified in advance. Is that really asking for that much? I mean, why do you need communications with any and all people that they were speaking to, I guess? As Ms. Lively's counsel noted, such a limitation is inappropriate given the purpose of the specific discovery sought and the purpose of discovery generally. And guys, I thought they did a pretty good job of lining up why it was inappropriate to ask for like such a broad scope, like, communications potentially with doctors, with lawyers, with spousal communication, stuff like that. So I don't know. We'll see. Okay. As Ms. Lively's counsel noted, such a limitation is inappropriate. The burden of persuasion in a motion to quash a subpoena is borne by the movant. In re-subpoena served on Lloyd's Banking Group, let's see what they said in that. Oh, hold on. There's a footnote here. I want to make sure I don't miss anything good. Let's go to that before we move on. Telephone numbers identified in advance. Okay, and the footnote 1 says, to crystallize their position as to the subpoena's putative overbreadth, counsel for the Wayfarer parties indicated that the subpoenas, as issued, would problematically reveal whether Mr. Baldoni communicated with 5 mistresses or whether he had communication with 5 psychiatrists. While a non-content subpoena would not reveal the identity of either mistresses or psychiatrists, it would reveal vitally important information about the phone numbers defendants contacted and when they did so, each of which is highly relevant to Ms. Lively's retaliation and defamation claims, as well as being entirely permissible in the course of ordinary discovery. Okay, how does it not reveal the identity of, I mean, I guess it doesn't reveal the identity, but it does show when there was communications with these certain phone numbers, and these phone numbers could then be linked back to mistresses, I suppose, or psychiatrists. I mean, I'm going to say that they're just being a little hyperbolic here, but all right. Okay, let's see. The Wayfarer parties have fallen far short of that burden, making instead only general and conclusory objections as to the overbreadth of the subpoenas. I never want to say overbreadth again. Initially going so far as to assert that no case law needed to be shared with counsel for the Lively Reynolds parties on this issue. Courts in this circuit have consistently held that it is insufficient for movements to make only general and conclusory objections in the context of a motion to quash. The Wayfarer party's most recent letter underscores their fundamental misunderstanding of the fact that discovery of carrier records is not only permissible, but routine in federal litigation. In the words of their own cited authority, the only question before this court is whether the disclosure of the telephone records is reasonably calculated to lead to the discovery of admissible evidence. Okay, so why is narrowing the scope a little bit going to cause so much of a problem? Shouldn't they be able to like seek out certain communications with certain people without having to see the entire phone record? I don't know. That's just my understanding of it, is that yes, it's kind of overbroad, but again, I'm not a lawyer. You guys know that. So I'll have my friend Omar might, go over that. Omar, the Tilted Lawyer. He's been on this channel a couple times for this case. Here, the parties are at the outset of discovery. Ms. Lively seeks communications among the Wayfarer parties and specified other individuals who have already appeared on communications tying them to the performance of publicity, crisis, or digital services for Baldoni or Wayfarer. Such information is reasonably calculated to lead to the discovery of admissible evidence regarding communications not only among the defendants, but among the larger network of individuals who perpetuated the untraceable campaign against Ms. Lively, and, as in sovereign partners, the requested records fit easily within this broad definition of relevance. Okay, and then they're citing some case law down here, or some case outcomes in the footnotes. Also, this footnote says the remainder of Wayfarer parties out-of-circuit cases address requests for content records. All right. Or do not relate to carrier records at all. Okay. The Wayfarer party's baseline objection to the production of carrier records, that they reveal communications with others, fails to acknowledge that there are no privacy or privilege interests in such information. Okay. Here they're citing a case ordering the production of numerical information, including timesheets, billing reports, and telephone logs concerning communications between defendants and their attorneys, because none of the sought documents revealed the substance of any privileged communications. Okay. I leave the case law stuff to the law tubers, guys. The Wayfarer parties have not identified legal authority standing for the proposition that subpoenas to telecommunications carriers must, or even should, be limited as they propose, and to the contrary, courts regularly permit such discovery. Hey, Snitzel Ninja, what's going on? Hey, everybody, I'm just checking in on your chats real quick. All right. We got more case law stuff here. Moreover, the Wayfarer parties continue to fail to address their lack of standing to assert such objections on behalf of the non-party individuals whose information is sought in the subpoenas. In the interest of resolving the parties' dispute, and notwithstanding the appropriateness of the initial subpoenas, last week Ms. Lively provided, through counsel, notices of intent to serve modified subpoenas to AT&T, Verizon, and T-Mobile US. The modified subpoenas remove the request for location data, further tailor the applicable time periods, and specify on their face that they seek only basic subscriber information, that is, call logs and text logs, reflecting non-content numerical information regarding ingoing and outgoing calls or text messages, related to identified telephone numbers over specific time periods. Okay. I mean, that sounds a little fair, but I'm looking at this and I'm like, there's still something about this feels a little like, even if you think it's inconsequential, people have a right to privacy as long as like it's not relevant to the court case. So still, notwithstanding defendants' continued objections to those modified subpoenas, Ms. Lively stands ready to issue them pending a resolution of the present motion by this court. Those modified subpoenas, like the initial subpoenas, are reasonably calculated to lead to the discovery of admissible evidence regarding such matters as a pattern of communications among the Wayfarer parties and unknown associates during Ms. Lively's alleged harassment, as well as the inception, duration, and scope of the untraceable retaliatory campaign against her that followed. I mean, like I said, it does sound better, right? But it's still, to me, it sounds like a little bit of a privacy violation. Even if it's non-content records, you shouldn't be able to see when someone's communicating with like a doctor or, anything like that. And they did point that out in their letter response that we read earlier today. So, hey, Palaver, what's up? Is it Palaver or Palaver? Okay. Anyways, here's a footnote here just talking about more case law. And that's it for this one, guys. I'm going to keep an eye out in case they decide today to file that response to the proposed protective order, which Justin's side's response to that is due tomorrow. However, maybe they'll put it in early. We'll see. Thanks everyone for being here. I appreciate all the support, and I will see you guys again very soon. Actually, I'll have another video out later tonight, hopefully around 9 o'clock or before 9 o'clock. I'm just gonna go through some of the recent documents and talk about like the kind of psych standpoint where like you guys who have watched my channel know I'm a psychiatric evaluator. I'm not a psychiatrist. I'm not a therapist. However, I do specialize in acute psychiatric crisis and certain behaviors, and I work with ER doctors on that. And so I'll kind of be going over some of this stuff and pointing out where I think some things are kind of manipulative if tailored to the public. Like when the public is reading some of this stuff, like for example, when they use Justin's words against him and stuff like that, why that's sort of manipulative and what that intends to do and how that sort of grips you emotionally if you're somebody who's kind of on the fence. And I just want to kind of look at it from that angle for a little bit. But like I said, that's probably not going to be a live. That's going to be a pre-recorded, and I'll have it up tonight, provided nothing else hits the docket that I have to work on. So I will see you guys at some point tonight, either for that or for the update on the protective order stuff. So thanks, everybody. I appreciate you. Bye.